24, the Punnen Kicharia.
But in this case, I am the daily wager employee, my lord, and I have appointed it before the respondent number 3, my lord. I have been appointed on the data entry post, my lord, on 1/8/2018, and I have been removed orally by the respondent number 3 by oral submission that you may not come to the office, and the same has been filed by the respondent authority has issued the notice on the date 16/1/2023, my lord. And I have also made the representation and made that, my lord, kindly accept me because there was no opportunity of hearing. Although the main allegation is that, my lord, इन्होंने लिखता है कार्यालयीन कार्यों में लापरवाही, समय पर कार्य न करना तथा अनुशासनहीनता एवं विभाग की गोपनीयता भंग की गई. But there was no document in the face of the reward, madam, which shows that I have committed any error in my job, my lord. And also the previous authority who were who were earlier appointed has also given me the excellence letter that my work is very satisfactory. That was an extra P4 without any document, my lord. Without any justifiable reason, my lord, I have been removed from my service, my lord.
Yes.
Reply, as per the reply of the state, my lord, there is some negligence on the part of the petitioner that he has taken some money from the handicapped persons he used to, and he was not performing duty sincerely. Upon that
notice दिया क्या उनको? क्यों ना हटाया जाए आपको करना?
There was not mention of the notice. Though there is a, my lord, may appreciate the annexure P to page number 14. Last 4 line में there is earlier order of 30 दिसंबर, मैं पढ़ देता हूँ my lord, last 4 line. किंतु दिनांक 30 दिसंबर 2022 को आपके द्वारा मुझे बिना कोई उचित कारण नोटिस से हटा दिया गया है. There is some order before that also, 30 दिसंबर 2022, and that order which they are challenging is 16/1/2023.
30/12/2022 को मेरा ओरली उन्होंने बोला हमको कि आपको हम कल से काम पे मत आना, हमने उसको मेंशन भी किया. और उसके बाद 16/1 को हमने उसके बाद में 3 दिन बाद आफ्टर लैप्स ऑफ दैट 4/1/2023 को हमने रिप्रेजेंटेशन दिया है. इट इज एनेक्चर P2, my lord, जिनको ये पढ़ रहे हैं उसमें भी मेंशन किया है. किंतु दिनांक 30 दिसंबर 2022 को आपके द्वारा सो एंड सो मुझे बिना उचित कारण की नौकरी से हटा दिया गया, जिससे मुझे मेरे माता पिता सो एंड सो अन्य आवक संबंध नहीं है, ना ही जीवन यापन हेतु मेरे पास कोई भी कार्य है, my lord. इसमें उन्होंने पूरा अपना एक्सप्लेन किया है the grievances, but there my submission is that, my lord, no document has been of the allegation that कि मैंने किसी से पैसा लिया, ऐसा किसी एक का कंप्लेन भी होता मेरे खिलाफ में तो my lord मैं अपनी नेग्लिजेंस मानता हूं, my lord. बस रेस्पोंडेंट अथॉरिटी चेंज हुई और मेरे को वहां से हटा दिया गया, my lord. उससे पहले मेरा कोई कंप्लेंट नहीं है लास्ट 2 साल में. 1/8/2018 से मैं वहां पर था, my lord. 30/12/2022 तक, my lord. Also I have one judgment reported in 2023, my lord. Para number 17 is relevant.
Paragraph?
Para number 17, my lord. May I read, my lord? It is a well-established principle of administrative law that an adjudicatory body cannot base its decision on any material unless the person against whom it is sought to be utilized has been apprised of it and given an opportunity to respond to it. Surviving the precedents existentially in so and so treatise on the principle of administrative law. Note that. मरोड़ उसके बाद में वो पूरा डिटेल है. And the same has been allowed, my lord. And my case is also similar, my lord. No opportunity of hearing, no document on the record, my lord. Only that I have taken money. This is my allegation. This is the allegation on part of the respondent, my lord.
सिविल कॉन्सिक्वेंस है इसमें तो आपने उनके खिलाफ कुछ एलिगेशन लगा दिया है.
एलिगेशन मतलब इनका यही कहना है कि हम किसी से पैसा ले रहे हैं. मतलब मेरा ये कहना है कि मेरे खिलाफ अगर कंप्लेन होता है तो मेरे को उसकी कॉपी देते हैं. किसने कंप्लेन किया उसकी भी कोई डिटेल होती है कि इन्होंने आकर आपके पर्टिकुलर आपके ऊपर एलिगेशन लगाया कि आपने उस दिन इनसे पैसा लिया. ये वो केवल एक 30/12/2022 को कल से मत आना बोल दिया और फिर उसके मतलब हमको
देखिए श्री पूर्णेंद्र Kacharya for the petitioner, Shri Kalpesh Ruparel for the respondents. Following relief is claimed in this petition. Facts of the case in nutshell is that the petitioner was initially appointed in the month of February 2018 on the post of data entry operator with the respondent number 3, and his appointment was on the post was purely of daily wager. Post of. Since then, the petitioner was performing his duty with Respondent number 3. 30th 12 2022, the petitioner was orally stopped from coming to the work. Thereafter, he made representation in this regard in Annexure P2, and later on, the impugned order, Annexure P1, dated 16/1/2023, was passed by Respondent number 3, removing the petitioner from his services, leveling certain allegations with regard to negligence, failing to perform the duty, failing to perform the work in time, and breach the secrecy of the department. Next paragraph. The defense counsel for the petitioner submits that the petitioner was working on the said post with honesty and sincerity, and looking to his work, sincere work, a certificate dated 13/3/2019, Annexure P4 was also issued. P4 quali was issued. He submits that before passing the impugned order Annexure P1, the petitioner was not afforded any opportunity of hearing. He submits that the Annexure P1 is having civil consequences on account of certain allegations. The service of the petitioner is terminated. If further submits such order, if such order is allowed to stand, it would cause prejudice in the future employment of the petitioner, and such order cannot be passed without giving a reasonable opportunity of hearing to the petitioner to reply to any allegations which are leveled against the petitioner. Therefore, he submits that the impugned order Annexure P1 may be set aside, and the petitioner may be reinstated to the services. To bolster his submissions, he placed reliance upon a judgment of the Honorable Supreme Court in the case of Deepak Ananda Patil versus the State of Maharashtra and others, reported in 2023 live law within bracket SC, capital SC 30, in which the Honorable Supreme Court observed in paragraph 17 as under. Per contra, Shri Ruparan submits that the petitioner was appointed on daily wages at the collected rate, and the engagement of the petitioner was made as per the requirement of work. The disengagement of the petitioner has been made on the account of negligence attitude of the petitioner towards law, and also on account of misconduct being committed by the petitioner. It has been further submitted by Shri Ruparel. The petitioner used to remain absent from the duty without making prior intimation to the authorities. The allegation is also leveled against the petitioner that he used to recover money from differently able persons towards providing benefit under the government schemes. He submits and says the petitioner was on purely a daily wages employee, there was no necessity to issue any show cause notice. But the learner counsel for the participants the report. From the perusal of record, it appears that the petitioner was engaged as a daily wages employee with the respondent number 3, and Annexure P4 colony are the certificates which have been issued by respondent number 3 with regard to his performance in the office, and was found to be in good footing. The impugned order Annexure P1 was passed, admittedly without affording any opportunity of hearing to the petitioner or any show cause notice being given to the imposter. The Annexure P1 itself indicates that there are allegations leveled against the petitioner, and the order dated so and so is of which may result into civil consequences. The return filed by the respondent also indicates that certain allegations were leveled against the petitioner. Full stop. But the fact remains, before passing any order on such allegations, before taking any decision on such allegations, it was imperative upon the respondents to give an opportunity of hearing to the petitioner, which naturally justice mandates. Supreme Court in case of so and so में अंदर में लिखा करेंगे. In light of the above, the impugned order cannot sustain and set aside. Petitioner is restrained to his services, since the order is being passed on technical grounds, the respondents are at liberty to take appropriate steps against the petition after following natural justice.